Courtroom etiquette is a very important, though understudied, aspect of advocacy generally, and it is well worth looking at. What I would suggest that people would do is this. First, you must think about what it means, and you must understand the importance of it in terms of being persuasive and listened to and the like. How to do that? I think that it is an important aspect of the matter to study the conduct of others, watch the conduct of those against whom you're appearing, with whom you're appearing, and simply who are appearing in courts where you're obliged to be for whatever reason. So in a sense you are learning, as humanity does, from the actions of those who've gone before. The second thing you can do, of course, is you can go to seminars or lectures where the topic is discussed. Not all that many of them, unfortunately, but those that are on are often well worthwhile attending, and I would certainly suggest that to you. The third thing, I think, is simply act in accordance with your own understandings of the dictates of common courtesy, because so much of courtroom etiquette is nothing more than that. It is simply common courtesy. There are a number of matters which are observed which may not immediately occur to you simply out of reference to common courtesy, but those matters can be quickly picked up. For example, if your case is finished, you don't rise and leave the court with the judge sitting there staring at an empty court. The etiquette demands, for example, that you remain at the bar table until such time as either the judge adjourns the court and leaves the court, or alternatively, as sometime, or the next case turns up and is called. When it's called, you rise to your feet, you bow to the judge, you walk out. In occasional circumstances, a judge seeing you sitting at the bar table with nothing to do and nothing to say further will simply say, "Please don't wait," which indicates that he or she has some further administrative material on which to dwell. But at the end of the day, the answer is you must use your common sense, certainly, and apply the rules as far as you understand them. And if you don't understand them, then go and talk to somebody who does and say, "This is what I did, I'm not sure it's correct. Do you have any advice?" And assuming you've consulted the right person, then they of course will be only too happy to help junior or new practitioners. The absolute fundamental of presentation in court is to know your subject before you get there. The essence of good advocacy is no surprises. You go there, you have a battle plan. You may have it in formal form, i.e. notes of some kind. You may already have done it by way of written submissions, as commonly happens in the appellate courts. Or you may have 3 ideas that you have scribbled on the back of a piece of paper after you sat down at the bar table. But however it is done, you must have some plan of how the things are going. The measure of your success, of course, will very largely be dictated and will be self-evident from whether or not you get through without any surprises. But a case that has been run from go to woe with no surprises is a well-prepared and well-presented case. You may not win, but you're not paid to win. You are paid to present to the best of your skill and ability within the rules of the court and the rules that govern the conduct of advocates of all stripes. And if you've done that, you've done your best by the client, then that's a sort of a win for you personally at least. You've done your job and you've done it as well as you possibly can.